fly back like Sunday morning. We had 2 flights canceled on Sunday, and then Southwest couldn't get us on until 5 their time on Monday. Then we had to fly through Milwaukee.
My parents had a really similar experience. They were trying to get out here for Friday night and didn't get here till Sunday night.
Really?
Via Chicago and Kansas City. I'm like, you need to just skip the entire Midwest.
Yeah, it was ugly. Plus, we'd done this competition, this appellate competition.
Is that what you're trying for?
Yeah, we all did like terribly. It was this like demoralizing
Insult to
experience.
injury.
We lost like every round. We were in like both DU teams, you know, some by like quite a margin.
Is this the one we went to a few weekends ago was just the negotiations, but this is your appellate team?
Mhm.
Okay.
And so it's like this whole demoralizing weekend where you've been like pounded down, and then it's like we can't even get out of town. We're at the airport hotel. Like, oh God.
Does anybody have any idea how much it actually costs to take the bar exam?
The application's $600.
Oh,
670.
just shelled out for the Barbie class. This is rough.
No. Did you see the email about like if you need extra loans?
That's what I just saw, and I'm like, how much are we talking about here? Because I thought with my job I'd have a nice little cushion.
Yeah, it never
It's
ends,
just
right?
rapidly disappearing.
Oh. Okay, we'll go ahead and get started, and if Will gets here, then we'll incorporate him. But what I want to do today, so on Monday we talked about, really we talked about ideas for the most part, not so much about the structure of the petitioner's brief. But today I want to focus on structure and the precise arguments being made in both of the briefs in preparation for your drafting your judicial opinion. So what I think we're going to do is a little active learning exercise, very exciting. And Bill, I'm assuming you probably only read the brief that you had.
Yeah,
as opposed to what I just gave you.
touched
Okay.
this
So, Bill and Allison, why don't the two of you, I'd like you to do this as a board, I want you to outline the petitioner's brief. And
Do you
then
happen to have an extra copy of it? I just realized I left my copy in the car.
I mean, not extra, but.
Look at it. Thank you.
And what's I going to do?
Yes, you guys are doing the respondents.
Okay.
Yeah, so the three of you then do the respondents. And what I want you to do, you know, obviously the person with the best penmanship perhaps could be the secretary for the group. But what I want you to do is to write on the board an outline of the brief to which you've been assigned. And start with the headings that they give you. And that, you know, that are obviously reflected in the table of contents, but then I want you to kind of dig deeper and figure out sort of what is really going on in each of those sections and state it in your own language. So unpack it a little bit. And I'd like it if you can try to reduce the argument in each section down to some sort of IREC. Okay. Which, you know, will be a little bit challenging, but I think is a good exercise. I mean, to me, in some ways, these briefs are very, you know, thematic and not quite as doctrinal as I would expect. So it takes a little bit of, you know, massaging to kind of figure out exactly what it is that they're saying. Okay. Any questions? Yeah. And we want to leave enough time to start talking about your idea for your
I like your 4-color pen too.
Good.
Red.
Although it might not be like, sometimes I have a 4-color pen that's like out of one color, so it will like totally depend on the sort of right?
That's right. Gotta hit the series.
So it's you, Kira, and Will.
Let's go, team. Bring stuff down.
Yeah, that sounds good. That sounds very good.
So you guys should go right to the board.
Yeah.
Okay.
Okay.
Is it fair to assume that I
You're like a pretty,
Actually, now I get it.
well, you could start with.
I like to
point out that
pretty Oh, yeah, do you guys need do you have a working pen?
Actually,
Okay. So literally the first step, I mean, what I'm kind of envisioning is, the first step is, write down the headings, and then I want you to unpack those.
Spread them out.
Yeah.
I can leave you okay, so the first one is standard.
And I want you to also just, you don't have to include the other introductory sections, but I want you to include the intro as well, because the intro is a really important part of both of these briefs.
Wait, should we start at one that we should have top? Or I guess it doesn't matter.
Logistics.
No, linear.
Yeah.
So I guess intro first.
Okay.
We have to do the intro, or we do just
I'm
the?
sorry.
Just the intro and then the
This one
arguments.
was the top.
Yeah. So in terms of intro, we're talking like,
The introduction.
I didn't even like summarize all of this.
No, the
intro.
introduction is a separate section. The introduction is,
Like-
where they introduce their themes.
Intro to our summary.
And so, part of the idea is that, well, how do you actually best represent this? I like the column idea. I think that's kind of, that makes sense. But, it's, part of this is that you guys are supposed to try different things and see what works, right?
Well, we like,
guess we can
we
skip
like,
that.
he said he likes hierarchy vertically.
Yes, that's,
Yeah, we are summarizing, basically.
Total Excel spreadsheet here.
all right, nice.
Yeah. Issues across the top. Iraq going down.
Good.
Because the 30 will be due
Oh,
process.
that's a good way to do it.
Don't steal ideas.
No, steal ideas. This is great. This is exactly, I want you guys thinking
Due
about.
process.
Due process is on board.
Just gonna do
I think, yeah, I think we should do
I was kind of
one.
two, like,
That's a good idea.
it's not taking right away.
Yeah.
or keep
Yes,
Kind
my
of
favorite.
is, like circuits going back and forth, right, was given and then taken away.
Okay.
So two is just something,
Wait, so this one is not a defining purpose of marriage? Because they're saying it's fundamental, so is that a strict scrutiny?
Conclusions from first.
Yes.
That is?
Sorry, I was saying yes to you. Go ahead and get all the main
Yeah, yeah, yeah,
conclusions
yeah.
up there.
Come
So,
back to the subsections.
marriage is a fundamental right.
Well, that's like not, that's A, not 2,
So-
so I don't know if he wants to just go through.
But I think that these are like
Yeah, what's,
under
what's,
due
what's
process.
the-
Okay, yeah, you're right. Equal protection.
4 is equal protection.
So to say this
3 is due process.
concisely, I would
Just put down
say.
here.
Yeah, gotcha.
But on our numbering, is it for equal?
Yeah.
Okay.
Intro, standing due process.
Okay, equal protection.
Yes. And if you guys want to conform your numbering to the Roman numerals in the brief, there might be an advantage to that.
Alright.
see,
I'll go next.
Roman
Roman.
So that's actually Roman numeral 3. Because intro is a classic equal.
It seems like,
equal.
I mean, they give sort of short shrift to due process clause stuff, and I don't understand.
Where are we going next?
So we'll just have to change
Or what,
this
I
to
think, what
Roman
the
numeral
equal
2.
protection clause means.
And then we could do this as an
Let's take a look.
Or like, you know, like,
Do you think
whenever
that
somebody-
there's stuff missing in
Well-
their brief?
maybe, but also it's like, whenever anybody says fundamental rights and stuff, I always think that's supposed to go
Yeah.
like in the due process
So,
clause.
yeah,
Shall.
so
instead
a
of-
quick review, guys. Under, the way that I think about the equal protection clause is there are 2 prongs. One is the classification prong, one is the fundamental rights prong. That a fundamental rights-based equal protection claim is different than a due process claim because it has a classification of persons that's discriminatory. Whereas a straight due process claim doesn't have to have a facial classification of persons that's discriminatory. Okay, so there are sort of, it's for the due process, angle on equal protection, but it's different than a straight due process claim.
Okay.
Okay?
We could do B over here, or something like, which is,
Just
I'm gonna put this in.
yeah, or directed and
I mean, I would
timing.
probably say like,
So, yeah, start with what they have, and then what are they
Basically,
really?
the law does not, or their, the government
What are they
does
talking
not
about?
survive strict
So
scrutiny.
taking away rights.
Yeah.
And it's distinguishable.
That's what, that's.
So what
That's what I was
what
asking.
might use right here,
Yeah.
timing
She was saying
argument,
yeah.
and then write
said
your
yes.
understanding of that
Okay.
argument underneath it.
Okay.
The defining purpose of marriage. That,
What is their timing argument?
Well,
So part of it, just one quick thing, sorry. Part of what you guys are doing, you're rationalizing these arguments, okay? They presented, the parties have presented this in a way that makes sense to them, but you need to present it in a way. I mean, when you look at these equal protection cases, they kind of all go the same way, right? I mean, it's about what level of scrutiny. It's about what is the right at issue. It's about what's the classification at issue. The parties didn't really follow that, especially the petitioners, to a T. So you need to make it fit with the structure of equal protection doctrine.
so it's like thematically, it's how we look at timing, right? It's, you know, we have thousands of years
Yeah,
of
I
human
think that's
history, and gay marriage is the big change, not.
Well, that's sort of more in the intro, is that.
Narrowly drawn
right,
circle.
the theme about- And there is a video tape of it in our class from Monday.
Okay.
But because we talked a lot about the themes, basically. But so their argument, Roman numeral 2 argument, I think this is really about Romer not being controlling precedent here. Right?
Yeah, especially the B.
Yeah, definitely the D. But it's sort of, you know, again, if you were to IRAC, that's kind of, well, what is the issue that they're talking about here?
younger.
You know, is the issue,
Are you really worried about this one?
you don't have to do a lot with standing, guys, unless you want to. I think it's kind of a,
It's kind of already been decided.
yeah, it has. I don't think that's going to be dispositive in this case.
Sexual orientation triggers.
You know what, you can also do the A and the B, because that'll probably make it easier, because they're a little bit different to do.
Okay.
Yeah. So what's the point in section 2A?
The difference between taking away a right that was previously given, as opposed to one that hasn't existed historically.
Okay.
What
are they saying?
So with a law
Prop
like
eight,
Prop 8, basically laws that prohibit gay men and lesbians, so you can say Prop 8. Prop 8 doesn't.
Saying it doesn't matter at all. Like, you know, California's given a right beyond the federal constitution. It doesn't, they're obligated to keep that right
Yeah.
forever.
So can you guys articulate that as a rule of law? So, well, sometimes you have to
So-
reverse engineer, right?
Yeah, yeah.
I don't think the issue's super clear. The rule, I think, is a little bit more clear, and you guys are kind
Or
of,
sole motivation.
So I would say whether,
start with the rule.
okay.
Start with the rule, and then work your way backwards.
Vanilla solely?
Only.
So the rule
Which
is
is, I would
states
think,
don't have to, whatever, you know, don't have to keep rights beyond federal constitution in some way.
Yeah.
So that's start the intro.
So then does the issue.
You know, we can change the number, so we can just, I guess, take away the number for intro and then.
I mean, you
for-
would think so.
For that one, Roman numeral 1.
That is correct.
Yeah, it's kind of interesting. California's constitution provides a right more robust than existing federal constitution.
So,
Well, you guys can tackle whichever you want first, I mean, if you want to dive into the process.
Do you want, okay.
You really don't have to talk about standing. The intro, though, I do want to talk about the themes that each party develops.
Should we just list out the themes from the intro?
Sure. That's a great idea.
fundamental rights, equality.
I think that
What is marriage?
makes
Fundamental
sense.
right?
Yeah.
Yeah.
Okay.
Protect, is that the right word?
Mm,
There's a timing element here, right, obviously.
I think Prop 8 is fairness.
And I'm just pushing out on this because it's really,
Preserve?
what is the gist of this?
Is it just, is the words to be not preserved?
Doesn't matter.
You just say motivated by.
Yeah,
That works too.
each word has a different connotation, right?
Yeah.
Protect doesn't have a real time component. Preserve does, but it kind of suggests it's been there for a long time.
Between?
Yeah,
Um,
you don't have to erase it, just like kind of show it.
Let's keep working on it. What are they actually saying here? Maybe you need
There
to
is some
break it into
subsections.
two clauses.
No, it's just.
We're just
Because you're talking about point in time A and point in time B, right?
Yeah.
So we could say topic is an exclusion.
So, if a state grants rights above and beyond what's guaranteed by the US Constitution, this does not prevent the state from later repealing those rights.
So they say that they've not set forth any justification.
Okay.
Right, it's this idea of rationing.
Basically, nor have they identified harm.
I don't see how that's different once you break it down, though.
State's not obligated to.
And then, yes, stigmatize.
I think there's a before and after component that I don't quite see in this rule statement.
Okay.
Right, so point in time one, the state gives rights above and beyond the US Constitution. Point in time two, they may permissibly.
The second part was there it doesn't address the state.
Think about it, I mean, if you guys want to go something different, let's.
There's
Yeah.
no justification,
I mean,
and they've
they're,
never identified a harm.
they're tied together because of,
Okay. It kind of bolsters.
yeah.
There's a little more, I think, in there is fundamental right.
It doesn't have to. Or
Okay.
it's allowed.
Yeah.
I mean, you don't have to say too much about it now because they get into it later.
Well, they talk
but-
about,
What do
like,
they talk about? What do they talk, they
It's kind of like a double negative, like they're not.
Love,
Love, right?
just
Yeah.
and creation.
well, that it's, they say that it's just a state right, or that it's solely to serve society's interests.
Right.
And then
I
it's
thought that was
this.
brilliant. I think that was really a brilliant sort of characterization because those are two fundamentally different conceptions of marriage, right?
And then,
Love and procreation, is that what?
Is marriage an individual right or is it a means of regulating society?
So how would you articulate that?
Yeah, which is basically what you're saying. Love, you know, the individual right to express your love for somebody versus society's interest in regulating the institution of procreation marriage.
State is no less free
So,
than state constitutional rights.
the aim of this-
Get that on the board
Exceed
somewhere?
federal constitutional rights and illustrates-
That would be under the marriage.
Or not,
chapter.
universally.
Okay.
So we could put there as a fundamental right, individual. Good. So put it maybe in parentheses at the end.
I'm not sure I understood
So the
what
last
you're saying about the
piece-
two timing components.
Oh, yes, and this.
Because I would say this is kind of
Purpose and
right.
effect is to stigmatize.
So,
This,
yeah, we have
Yeah.
that one or something.
and that's
But
a
we
timing
can-
issue.
Okay.
Right.
Yeah.
Point in time one, you give the right, point in time two, can you take it away? And then you're talking about B? Well, so you need to distill this, right? What exactly again are they saying there? They're saying that the Ninth Circuit characterized Romer as standing for.
oh wait, so we're done here? So there's
I
not
thought
two-
that you were.
Oh, I'm sorry, I thought you were saying
That's
there's
okay.
two timing rules.
Well, no,
Kind of go
no.
along
Okay.
with
I don't think so, not in that section.
Okay, I was struggling.
Yeah,
Okay.
there are two moments in time, is what I was
Okay.
trying to say, yeah.
What's the other option?
Okay.
It says,
An individual right.
So, analysis here,
Is this solely to serve society's interests?
California.
So marriage as an individual right.
Versus a method of regulating society?
Does that make sense?
So this is your conclusion.
Yeah.
And then, so then does our issue become whether the rights are beyond the scope of the US Constitution or not?
And then under that, I don't.
That would be a
sub-issue here, so your issue and your conclusion are gonna match up.
The state could
But really the issue they're saying is can they
deny
take
any
them
and
away?
couple the right to
When they
marry,
previously
because
agreed on it.
proponents are
So the
basing their
controversy
argument
here
on
is about
procreation.
this idea in the rule. It's not about the application phrase or application. It's really about,
So under
and they're kind of,
state.
it's not a straw man, but they're sort of saying, okay, well, what they're claiming that
Any
once you give rights, you
info.
can't take them away. Well, are they really claiming that? Is that really the basis of
I
respondents'
mean, they're
argument?
really attacking the Ninth Circuit.
Yeah.
But,
Right, when you ask, well, where did that issue come from? It came from the Ninth Circuit.
But it's still, I mean, it's still sort of a straw man, because the whole, I mean, it avoids the real question, because the real question is whether this is beyond US constitutional rights or not. Like, if you assume, if you already assume it's beyond US constitutional rights, then
I think there's something
So that's like tradition for the sake of
missing
tradition
from this, right? And this, the point of IRACing it is to identify the components and say, wait, if there's a fallacy here, where is it? You know, where does it begin, really? And I think it's, in a sense, it's a non-issue, right? I mean, the rule of law applied by the Ninth Circuit, well, this is the thing. The rule of law applied by the Ninth Circuit was not that under no circumstances can you take these rights away. But when you apply rational basis review, you don't ask whether, you have to ask
It's not a LSI.
whether there's a rational basis,
Yeah.
not for the end state of the law, but for taking those rights away. So it's a more precise inquiry and arguably a heightened inquiry.
you're saying this doesn't matter at all. That what, the timing aspect
I'm just throwing
doesn't create this heightened scrutiny or
And
shouldn't.
that's coming out more, right, in section B here, right, when they're talking about
But
wrong.
we're.
But yeah, I feel like this is kind of a red herring. I mean, I don't think that that's precisely the
They don't
rule of
have
the Ninth
standing because they
Circuit.
don't have an injury in fact and stuff.
But so part B, they're criticizing Ninth Circuit's rating of Roma.
No,
and then
So we need IRAC.
Okay.
You guys actually can switch
Standing.
So-
It's not.
This is not limited to state law, constitutional.
You're a master of the,
Change in the law.
That's why we have to justify.
So,
I don't want to teach.
Uh-huh.
you guys say here that you another.
And so you guys are gonna try to IRAC.
Yeah.
That's a little bit
Well, tricky. Can we plot, this is our initial issue and then just kind of break it into sub-issues?
Yeah.
Like whatever you
Oh,
say.
yeah. So,
Hit some notes.
So
the issue
sometimes
is marriage people, right?
I don't know that that's the issue. Sometimes you need to start with the rule and then figure out from that what the issue is and whether they framed the issue properly. What's the gist of what they're saying in this section?
Rule, no.
Well, before even going into.
So,
marriage,
like, I wanna say the
then
issue, like,
Talk about. They
the broad
conclude
issues.
as their kind of.
Obviously, did the Ninth Circuit appropriately apply Roma
Whatever they're
regulating
relying
more
on it
specific than that?
to even get to. Or I guess maybe is this talking about the framing of what marriage is? What do you think?
Well, let's go straight to the rule.
That's what it seems to say to me. They talk about in loving that
So I would say,
Lawrence.
under Romer,
Rule.
the change in the law
So what's
is the thing that must pass
What, read that heading.
rational basis review or scrutiny.
Is the rationary is fundamental for all people.
Okay, what's the point there?
I thought they were saying that,
Right, I mean, this, like, the idea is that you can't, if you say, is there a right to same-sex marriage, what you're essentially saying is, do homosexuals have,
So it's the same.
enjoy the right to marriage?
They weren't saying the rumor is the same.
Right, so they're making a point here about how to frame the issue,
Not given.
and also that larger point of, when we say marriage is a fundamental right, what are we talking about? Are we talking about the role, the historical role of marriage as regulating procreation, regulating society? Or are we talking about liberty, privacy?
Yeah, constitutional right behind it.
Yeah, okay. So,
So they're trying to broaden it.
so what's the rule? What's the rule? They're saying these cases stand for the proposition that.
Distinguish.
yeah,
Wouldn't that be the rule, the right to marry is fundamental?
So we all agree that the right
There's
to
lots
marry is
of, I mean, there's
fundamental.
lots of, their arguments are
What are they citing these cases for?
privacy.
The Supreme Court has held that even, like, so we all know that it's a fundamental right, but the Supreme Court has held that you can't exclude certain people from this fundamental right.
And that goes to that thing of whether it's an individual right versus
Instead
societal.
of, okay, so instead of withdrawing or eliminating rights, which they're
That's what they're
obviously
talking,
arguing
that's the
against.
reason why they're talking about the analysis. You know, what
I mean, aren't they
is
still arguing
marriage,
that,
according to them, versus according to the
that
petitioners?
you,
Start sketching it out? Yep.
So.
that all that needs to
they're
happen
saying,
is a
so
new law?
fundamental
needs
right,
to
would it
be-
be that it's an individual right, that. And then, but then they say, I guess they're kind of listing the characteristics of what the individual right is. But then should we be mini-max for all those?
So their goal here, the essential goal is to characterize the right to marriage.
Yeah. So it's saying, look, just basically marriage is a liberty available to all people under the Constitution.
Or the fundamental right to marriage includes.
What is it about marriage that's fundamental? That's really kind of the question here. Okay.
So is it the right to choose?
All of these things.
It's all those things.
It's all these things. So you can have a comprehensive rule,
See, but-
okay, that the court has recognized marriage as being fundamental on these various bases. Are those bases implicated here? Okay.
So.
That's
We do
That's gone.
know what we- I guess, so she's like, fundamental right to marriage includes.
What's the assertion?
And then we can
What's
do
the
that,
assertion?
does not include, right?
What does that mean?
We think it's,
Say.
well, it's kind of weird because their ultimate goal is to kind of distinguish Rome.
Yes.
But what they're saying, it seems like, is,
Four values of fundamental right.
you know, Romer and the court as a whole applies the same analysis whether you're withdrawing rights or whether giving them out in the first place. Like it doesn't,
Under Lawrence.
the rule is that doesn't change the analysis.
Okay, okay. So, again, they're teeing up the issue with the Ninth Circuit's reasoning. Okay, the Ninth Circuit contended
wanna do-
that Romer stands for the proposition
Well, she said
that
the issue is-
there's a different analysis that applies, okay?
I don't think
And,
she's
you know, the
saying
issue
that.
is what does Romer stand for?
What does it
You know,
mean?
And then,
Okay.
what does Romer stand for?
So let's do the roll first.
Yeah, so the court has recognized that marriage is a fundamental.
Okay,
right
so
that includes-
the take home that I'm getting from this is they're saying that it doesn't matter whether
Well,
rights are
can we just put that on the board?
What matters is
and then
that
we can start listing them?
the ultimate law still passes rational basis review, right?
Yeah, just that the analysis is unchanged by
So, the
withdrawing
right
rights or
to
not giving them.
choose
Okay.
your partner.
Or even, I mean, even to simplify, like withdrawing rights is a red herring really, but
Yeah.
they're putting it in the Roman.
Well, okay.
Oh, I'm sorry, I shouldn't laugh.
Fundamental right to procreate.
The other thing is you guys are going to be reading so many briefs and you really are going to appreciate when the structure of the argument is clear versus, and these are both really strong briefs, but you have to turn it into a judicial opinion.
Association. So like here, the court has defined marriage as a right of liberty, privacy, intimate choice, and association.
The arguments in the one I was going to watch. I went and there was this guy, he said like 20 different things. Or just, their only question kept being like, what is the main issue? What do you really want to, like, over and over again?
Liberty, privacy.
And you'd just be like, so many things went wrong. You can't even-
Okay,
So
so.
Romer stands for a number of different things, yeah.
And then we could do what you were saying.
Okay, here's what I'm trying to say in a positive way.
Yes.
That, what they're arguing is that it doesn't matter whether rights were granted or taken away under Romer. What matters is that the resulting law passes rational basis review, right?
Okay, so that's the, now you're saying the categorical distinction.
Okay.
Okay, does rational basis review require justification for changing the law? Or does it only
Okay.
require justification for the law itself?
Okay.
Okay?
Okay.
And then, yeah, we don't think he's not.
So, I'm sorry, I need to write because that's how I think. My writing looks So there's kind of three questions. One,
So like this is all the stuff that includes, so then we're gonna do like does not include and then like.
It does not include.
Under B or still on small?
Just like out here, but not under me.
This
This
is
is
just
still
like
part
a
of
rule.
A.
Okay.
It's just like a lot.
Ability to procreate.
these are the three main things I think they're talking about what rumor stands for, okay? So, rumor does not change the recommendations from the standard. MSU failed in rumor because it was extremely broad, because it was an unusual type of law. And so basically, the Ninth Circuit's attempt to analogize Prop 8 and then failed, right? And then, I just find this so interesting.
Okay.
So,
that's our rule.
and then there's a character
So then
section
we
in the
need
end.
a issue and
And they say, well, rumor said man,
Yeah.
this is ill will, and then the court, Ninth Circuit said, well, you know, this wasn't ill will, right? So
So
that's
it
it.
is that the
So, the large issue, this could be, you know, the so-called
The same
rule
sex.
for the large issue of what does rumor stand for?
Mhm.
Or you could, you know, like you're going to break it out
Okay.
in one.
Right, because then they can say no.
So, this is the fundamental right to marriage. It would be something that apply to these couples. Or are they entitled to?
Well,
Move around, if you're having trouble, move around, you know?
it seems like it goes
Run through the end.
into
Sure.
tax or tackling this issue.
Is the ability to procreate necessary to marriage as a fundamental right, or is that a necessary component, or?
Right.
Are you guys surprised by how hard this is?
Yes.
No, because I'm still working through them. It's okay.
It
Okay.
seems like they're going to start attacking.
So I thought the democratic process was the first big theme.
All
Okay.
supporting that this is not a fundamental right of marriage.
I don't know if that's like specific enough.
That's actually right on, that's right on, yeah.
So, but then we need to talk about the application.
Yeah, it's on, when, I mean, page 23, the bottom, no state marriage, that's a statute.
What category you put that in?
Among its conditions for legal marriage.
Yeah, and then the
So I would say,
marriage cases.
Yeah.
I mean, the analysis is that there's no law that says that procreation
So the
is.
application down here, so that rule,
Yeah, maybe we can take out that A so that it doesn't get confused with application and put our R there.
it's just IRA. Application is no
How
state.
broad do you think you can make that?
When,
This is a question.
I mean, there's no laws, right? In
How
any
broad do you think you
state
can
that
make
say
the
that
criminal
procreation
implications
is
part? Can you make it
a necessary.
substantial state interference? Or does it have to just be criminal?
oh, well, okay, so
But if we want our.
not criminal, maybe I should say it's not criminalizing
It's
private
basically an
behavior.
application to the facts.
Mhm.
We would have to say
Or
that same-sex
like is
couples
the,
should have the right for all these things and the ability to.
I'm not sure about the
procreate
answer.
doesn't
I don't know if
matter,
they're
or,
making
you know,
a
just-
criminal-
right? 'Cause we want-
civil distinction or the state is
Yeah, well,
not
this, what you guys are struggling with is exactly what
broader,
you're
like the
struggling
state's not
with. Why does
intruding
this
in the same
matter?
Yeah.
Why are they
Here.
talking
Yeah.
about this? How does this
Well,
help
because
us
there's
solve the
nothing,
question?
yeah, rather California
Same-sex
simply reserved a
marriage.
special form of recognition, so they're not like
Well, because it's
theoretically,
talking about
like,
the
condemning
the
something,
things that are
especially
fundamental
to the
about
extent
marriage
that
that you should be
Lawrence did.
entitled to as a
Yeah.
fundamental
So, okay,
right.
so maybe we should
And the
say,
ability, or, you know,
Ah.
having children, or the ability to procreate is not something that you're entitled, I guess, entitled to as a fundamental right, as a fundamental element of a fundamental right.
What is the overarching point? Like, why do we talk about fundamental rights at all? Why does it matter?
It's to be,
Or
Due
do, I mean,
process
it's like,
entitles us life, liberty.
it's to be free from state the state imposing
Okay.
something, or, you know, so
As a
we free from
litigator-
state action.
Why do we care about fundamental rights? It's the equal protection plaintiff side litigator.
Standard of review.
Level of scrutiny,
Yeah.
That's what I meant.
yeah. That's brutal, right?
What's the difference between levels?
Well, yeah, so it's
Level of scrutiny is a
Yeah.
substantive constitutional
Sub-
standard. Standard of review is a procedural appellate review standard.
So what is the level of scrutiny for fundamental rights under the
Strict scrutiny.
strict?
And so what's the rule?
It has to be
Where a
narrowly
law, oh, yeah, right, that's right, but, so where a law
Burdens.
burdens a fundamental right, strict scrutiny applies. The question here is whether Proposition 8 burdens a fundamental right.
tailored. Okay.
And to determine that, you have to understand what is fundamental about the right to marriage,
Okay.
right?
Yeah.
So if marriage is only fundamental to the extent that it protects
Yeah.
accidental procreation, it's not implicated for these plaintiffs. But if it implicates these other
Cool.
values and rights,
Then I think
plaintiffs are
we
being
have like our not like Romer section.
are
So I mean, our issue is
I don't know
basically
what the-
whether
How you want to frame the
whether
rule.
marriage is a fundamental right is what we.
Sure.
That's tough because there's a
They don't
fundamental
copy
disagreement
burdens.
about
The
what
fundamental
monarchy
right
is.
of marriage.
So it's kind of hard to like.
or you could condense it, you could say, you know, does Prop 8 burden those aspects of marriage that are fundamental?
Yeah. It seemed like in the intro it was like, it was more of a straight distinguishing.
Yeah.
It was very
The
interesting
two
kind
is
of
very
interplay
sweeping, this is very
between the
narrow.
plaintiffs and this sort of idea of entitlement.
We
and
have
the
domestic
characterization of the
partnerships,
right.
so we're not that bad.
Wait, can you repeat that?
Okay.
Big change was getting married.
So should we say distinguishable from Roman?
There is, so what's the argument on the other side? Because the problem is you don't have the argument on the other side in front of you right now.
That, the argument about the fundamental right, that it's not a fundamental right, same-sex marriage is not a fundamental right.
Right.
So,
Yeah, that's
the question that
probably
is there a
the best.
difference between same-sex marriage and marriage or not? And then to understand that, you have to look at the qualities that make marriage a fundamental right.
So here's our qualities.
Yep.
But then they get into the whole rational, irrational thing.
But then shouldn't this, I mean,
Um,
technically be a nested IRA?
You could definitely do it as an exception.
So like the top page
But you don't
six
have to, I
there.
mean,
Mhm.
So. Yes, it does, burden.
how do you do that?
It inhibits two-partner,
Maybe
the
under
right to choose a
Romer, it's
partner,
like,
And it-
intimate choice,
talking
association,
about-
rights.
It inhibits all those qualities,
Yes.
or it burdens all those
Right.
qualities. And it
And then
it
we're
burdens
talking
that, but
about-
that's not part of the fundamental right.
Well, we don't know whether it
You
burdens,
the
I mean,
timing.
they're not able to appropriate
Back to the timing.
anyways.
But so are like second marriage.
Yeah, so it's not-
If you
doesn't
the
really
timing over
matter.
2,000 years,
Mhm.
this is totally rational.
Right.
Instead you.
What's
you
the
know, timing over
procreation
2
argument all
years,
about?
Then
If marriage is only fundamental because it is a vehicle for stabilizing procreation, what consequence?
It's like
Loving and brown.
Well, then we could
Then it's
deny the
only-
right to marriage for opposite sex couples who don't have the ability to
Right.
procreate.
Well, you could, so you could, basically what you're saying is that same-sex couples then don't have an interest that is being burdened in the fundamental right of marriage, it's just about procreation. The question of who they choose to exclude is a tailoring question that depends on the level of scrutiny. So you'll see these arguments will be echoing through the different stages of the analysis, okay? But the procreation argument
Raised explicit.
is relevant to the characterization of the marriage right. It's also relevant
It's
to
almost like
whether
the
there's
district
legitimate state
courts,
interest or
like,
compelling state interest in excluding this group, right?
So that would be over there.
Is that like Dollars v. Hardwick, where they,
What are the core
because they-
meanings of marriage?
just like sodomy could be opposite sex couples or same-sex couples, but they only applied it to
Like
same-sex
person.
couples?
Well, so they,
Um,
does it, the characterization of the right there was very narrow, right? And that was essentially the primary mistake in the reasoning in Bowers. So the Bowers Court didn't conduct a tailoring analysis.
Okay.
So it didn't come up in that level of the analysis.
But here in the tailoring analysis, that's where it could break, because
So-
if they're only enforcing against same-sex couples, when
Yes.
opposite-sex couples
Yes.
could be infertile, it's
Yes.
not narrowly.
So on a
is
rational
that-
basis
because
review,
race wasn't a
you
fundamental
can
right
pick and
there,
choose
and
who you
gender
want to
is.
exclude. It doesn't have to be precise. Under strict scrutiny, the idea of being over-inclusive, or in this case, under-inclusive, matters a lot.
Okay.
So the argument under strict scrutiny would be, there are lots of people who can't procreate. If that's the reason you're excluding same-sex couples, then you need to exclude these other folks as well.
Cool, I'm happy with the interpretation.
Yeah.
Okay,
All
so
right.
then for analysis for this, I don't know why that is so
Back to
difficult.
this hot mess. Okay.
You skip Stanley.
Connecting this all together, I guess. So would the analysis be marriages
I mean, really,
and
you have to-
marriage between same-sex
Here's one
couples,
good one, and that's what-
or they're denied? Keep working.
These are essentially like issue statements.
That's good, I like that. So this is my thing, if you make that, if, you know, a party were to make that
Do you
claim,
even want to
then you're
limit
saying
it
this is
down
a
to
gender case. That
same-sex
should get under
couples?
the
It's just
scrutiny.
that all people
You're essentially conceding that.
who have these qualities have the fundamental right
Yeah,
to
that's
marry.
true.
So then it would be, the analysis would be Prop A, burdens,
They're
the
trying to go
following.
from a broad perspective and say that marriage is the right
Do you want to leave
time.
the other words?
Yeah,
So
but I'm just
therefore,
trying to
Prop A
think how
burdens
into
are-
the analysis is what you just say.
EPC? Down with EPC?
Marriage is a fundamental right that includes all these people, and therefore Prop A burdens, burdens.
That's a circular reasoning. Because it includes something, doesn't mean it includes it. Right, you see what I'm saying?
Like equal protection clause thing here, because basically it's just like, here are the four real purposes.
Well, what's missing in their equal
So we
protection
should
clause
say,
analysis?
well, Prop A, something that the, so we should, the application is that
There's no
Prop A,
rebuttal of a suspect class,
we
right?
have to apply.
Yeah, so why aren't they talking about suspect class here? When are they
Because
going
it
to
denies people.
Wait,
When are they going to
That
talk
way.
about suspect classification analysis?
All of these
Their
things.
reply briefs,
Okay.
right?
And then.
Didn't that be that reply or
Prop A burdens.
argument, but I guess they
Fundamental
wouldn't be
aspects.
open to them.
No, they would be, I mean, it's hard to say how much the court would enforce it, but they would have waived essentially a rebuttal to the suspect classification analysis.
Maybe we should come back.
It's really hard because they're not talking about this in the language that you're used to.
Do we need to
I
add
mean, yeah,
something?
it's like there's no framework at all, it's just like,
Yeah.
here's the equal protection
Therefore,
clause
any
and here are all
law
our real
burdens it?
purposes.
So this is why,
Or is that
this is why
So therefore,
you really want to think about communicating to judges and the work
So,
product that they
because we're
have to put
saying,
out.
does Prop A burden
Right,
the
because
aspects
this
of
is not
marriage
very helpful
fundamental?
to the court,
The aspects of
honestly.
marriage
So they're
that are
basically
fundamental
saying
are
it's rational basis review.
Blah, 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 blah. Prop A burdens
So I would
these
say
ones.
For a couple of reasons.
Therefore, Prop A burdens.
burdens
same
fundamental,
couple.
the aspects of
Aspects
marriage?
of, yeah, I don't know. It's circular, isn't it?
First level
Isn't that
scrutiny,
what I-
Yeah,
it will be multiple IRACs
Right.
here.
I mean,
Okay.
yeah. I
So
know.
there are multiple
But then
issues,
this shouldn't
but,
be up till over here.
they say it's rational basis review, so that's the
So-
conclusion.
Then, all right.
How did they get there?
I'm sure, Margaret.
Prop A burdens the.
Page
Is
29.
there a position or
So then
not?
we should just
Similarly
list them.
situated? Yeah.
Burdens.
This relevant biological distinction dictates that the traditional definition of marriage be subject only to rational basis review. I mean, that's really weird.
Yeah.
But that's their rule. But they're saying Claiborne supports this. That's not right. Claiborne supports the proposition that actual differences in ability would preclude something from being a suspect classification. But it's conceded that there are biological differences between men and women, and it doesn't stop it from being an
So
intermediate
the
scrutiny.
conclusion is therefore Prop A
Right.
burdens.
But that's their claim. That's
what
the-
she said for their part.
Yeah.
What about like the Crawford and Baker stuff? Like, aren't they trying to kind of say this has already all been decided?
Yeah, so Baker, long time ago, the court denied certiorari in a case, I want to say it's a Michigan case, where the state court had said there's no right to same-sex marriage, or there's no constitutional issue in terms of excluding same-sex couples from marriage. And there's been a lot of discussion in the lower courts whether that's binding precedent on the lower courts. And, you know, some courts have decided that it was, and other courts have said no, because the Baker case was decided before Bowers or before Lawrence v. Texas. There's been a change in the law that eviscerates it.
Well, and then do we want to put that there does not burden, or, because it doesn't really matter.
Yeah, I guess I don't,
Does not
Doesn't
affect.
matter.
Yeah.
No, they want rational basis review.
You know the rule. Whether the rule is correct or not, and this is the same thing.
It's really hard for me to like put the rule in the terms because that to me is not what the rule is.
But take them at their word, okay? You're describing what they're arguing. You're not saying, you're not endorsing it as being incorrect, okay? So rational basis review applies where? What?
There's not a suspect class or
What is it, what are they saying is the determinative factor?
similarly situated.
And what in particular makes this group not similarly situated? Biological differences. And that's actually one of the themes from the intro that you can include up there.
So
Do you guys get what I'm saying about
if
how that's their claim on page
So then
29?
the
That's their
rule
rule.
would be fundamental right.
If X, then Y.
Or
If biological
subject, or-
differences, then rational basis.
Stricter.
Which is wrong. I mean, that's not what Claiborne says.
If,
That's not what the rest of the precedent says.
if
Right.
something burdens,
Um,
whether property burdens a fundamental.
I mean, it's weird. I don't know if it's some sort of a strategic
Fundamental.
A
sort of-
burden fundamental right receives
Arguing
strict
is why.
scrutiny. Is the language.
Because
When a
in the
fundamental
reduction
right
analysis,
is
it's all about the level of
it's
scrutiny,
subject
and
to
they make an
strict scrutiny.
incredibly weak argument on the level of scrutiny. We'll see what they do in the reply brief. So, all right, how's it going?
We don't know.
You guys are also smart that for you to be in a state of uncertainty, I think is very good for you.
You're enjoying this in
I
some
am.
level way, aren't you?
No, this is good because honestly, I mean, I just remember, because I never had to do this until I clerked, but sitting down with the briefs and trying to figure out how do I diagram these arguments
Yeah.
so I can see everything that's going on and address everything.
Which is narrowly tailored.
Okay, so now we move on to.
So- A fundamental right is burdened.
So
It must survive, or how do we get to it?
So now we're at rational basis review, right?
It must be
And
narrowly
the
tailored
governmental
to survive.
interest.
Yeah, so
Narrowly tailored to serve a compelling government interest.
So the law must be near the law.
Analysis, we just had,
Narrowly
So,
tailored
okay, so general law.
so it's legitimate,
Is it compelling?
legitimate interest and rationally.
What are you asking me?
Like means legitimate means
Yeah.
rational.
Yes.
Means.
Okay. So, you guys are still in section 2 due process?
So that's like the two-part rule.
Mhm.
Okay, because you have, this is part A, right? And then part B is the trial record and factual findings established that responsible appropriation is not going to be finding for purposes of marriage. Is that really what they're getting into?
Well, that would be this part, right?
Looking at your table, well, it does overlap with that. And so what's the relationship between part A and part B? But what are your table of contents look like?
not it's not the defining purpose of marriage?
Yeah. So that is the argument in that section. When you guys are asking, I think you mean a level of scrutiny or rational basis review, where do they?
Okay, so then we'll move on to their various reasons, their various government interests.
Yes.
I guess rational basis review.
Was that
Where are the table
here?
of contents?
Maybe under analysis.
3B.
Yeah.
So we said the government
So this,
are.
they're not
they're-
doing that level of scrutiny analysis yet in section 2.
So.
So
two
what are they
is
doing?
this-
What is the
what
point?
fact- Going back to the district court's
So-
factual findings and getting back to this point, that procreation doesn't matter. So it's just more of a factual
Not
matter.
the defining purpose of marriage.
You can erase mine too.
I don't know why it's
So-
hard being, honestly.
Yeah.
It's just kind of more
Yeah.
reiterating that
Yeah.
procreation doesn't matter.
Probably furthers the purpose.
So can we skip that?
Yes.
Does
The
procreation
matter
matter?
purpose of marriage has always been to regulate sexual relationships. Okay.
See, this is really interesting to me because they're responding to the themes
Proceed. Do you
in
want-
Fundamental
the
aspect of marriage.
Do you wanna list
petitioner's
all of them?
brief.
Yeah, let's list all of
Okay.
them.
But
Proceed with
where it
caution.
fits in the legal analysis is not really
Basically,
clear.
remember that.
And I think that's
Yeah.
kind of a shortcoming, honestly.
So I think we can just skip this part because we know that it's all about.
You can't
That's not
actually.
a-
Democratic authority.
Well, thorough. He's like, I do not want to leave anything. That's your type A, being like, no, I can't leave it blank.
All right.
We don't want to give it
It's like,
Good, this is good.
and it doesn't have this purpose.
This makes sense.
Oh, yeah, okay.
Okay.
So, sexual
They're,
so,
well, the
is it-
disperses.
so the issue would be
potential, but-
what is the level of scrutiny for sexual orientation?
So the precise argument is that sexual orientation is a suspect class. So that would
So it'd
be
be
the sort
government
of
interest.
starting point. I mean,
Okay,
it's
so
embedded
that's the
within what you're
rule.
asking, but so the issue is sexual orientation a suspect class?
Is not to.
Class is suspect when the criteria and then, the, application of criteria. And my point there is that you would want to do that in nested IRAC. But if you want to capture it with one big IRAC, then the rule just lists out the suspect classification criteria, and then in shorthand kind of explain how those different criteria are met.
So
She just said it.
sexual orientation is suspect.
I mean, so then these
I
are
don't, is that what she's, okay, yeah.
basically the same every single one, right?
Yeah.
So we're gonna put
This
this
is
in
legitimate interest.
Well, so so if you were to break this out into nested IRAC, is procreation and child rearing a legitimate state interest?
A group is
probably
a
the right
suspect
term.
class.
Yeah, there's
Well, so for each one of these, you have to say both, sorry. You would break these out into many IRACs, right? And so for each one, you would say, is it a legitimate state interest? Is it rationally related, right?
Okay.
Promoting responsible procreation and child rearing is clearly a legitimate state interest.
What is it? History of discrimination.
Is it rationally related? Do they address that?
Politically powerless.
But I don't know if you remember what I was saying now. All of these things, these giant IRACs you guys are doing, they would all break out to
Yeah.
deeply nested IRACs.
Yeah.
But you want to kind of try and capture the gist of the argument in this nested.
Ability to contribute to society?
They only need one of these to stay also in these three. It doesn't even matter what they.
They're throwing out various justifications.
Yeah.
Almost
But then
each one of
the
these
conclusion can be so general.
should be broken out.
Well, that's what she was
Well, the
talking about.
conclusion was,
That's
does
what we would
provide
want to do a nested
the
IRAC.
action is
This
in
one,
here.
this is
The action is to
yeah.
evaluate these, and you might want to make a note about, where are the weak spots in their argument, and how do they defend those weak spots? Right? What do they say about how
Same sex.
it advances
Sexual
stable
orientation.
procreation and childbirth?
Well, sexual orientation, I mean, gay and lesbian, I guess,
So-
gay,
Oh, yeah.
because sexual orientation is like the category, so, or, I don't know. I don't know.
Gay men and lesbians is how they have it in here.
Okay. How come they don't put gay men? I think sometimes, yeah, I think it's just different language.
Because don't you think lesbians is a pretty derogatory?
Never thought of that.
have a history of
Because if you look, like, let's specifically, for
I think we
example,
could just do
at,
a pull have a history.
the argument on appropriation sheltering, right? So, small letter A.
Yeah.
Beyond dispute, the state has compelling interest, so they spend some time talking about the fact that this is compelling interest. Probably more time than they have to, I mean, it's really pretty self-evident, right? And then you go to page 38, small
What is
letter B,
ability to contribute to society?
and this is where they start to explain
No,
how
because the
Proposition
conclusion
8
is therefore
advances
gay
their
marriage
system.
is a suspect.
I mean, if we went through each one, you'd have to go through and conclude.
Essentially, and it really depends again on how you interpret rational basis review. They're saying,
What is that?
this group is different with respect to procreation. Therefore, it's rational to treat them differently. We talked about this, Bill, on Monday.
This sounds weird.
This idea, okay, step back for a second from all the history, right? If the state wanted to create an institution that would capture people who are capable of accidental procreation, would it not be rational to include only heterosexual couples within that institution? Right? It is rationally related. Now, is there something else wrong with that discrimination? Perhaps, but from a pure deferential rational basis review standard,
Right.
it pretty much flies. They're saying they're different, so we can treat them differently.
We don't
So-
mandate marriage with sexual.
Can we add another therefore, or is it cheating to say like therefore?
It doesn't
the
matter.
user-
I mean, that you're making an under-inclusiveness or.
Well, we're like,
It doesn't matter.
we're allowed because in order for the equal protection clause to be triggered, then either it has to be a fundamental right or they have to be a suspect class. So we're saying they're a suspect class, and then we get there, so we're like already.
So, I mean, it would be like if we
Very
did
different.
We're
another.
gonna have to do a bunch of this.
Right.
Unless we want to
Make
break out of it.
This is the
But
one.
basically, we're like, we know.
Well, this is
Strange.
key IRAC.
It seems like.
Because, in my view, with my scholarship in this area, but,
Argue that it is suspect.
because the question is what is animus? And they say animus is ill will. And that was not the only reason it was enacted. I mean, whether there's animus in this case or whether that destroys.
But then there's like the exclusion part of it.
Totally depends on what your understanding of animus is.
This is
which
just an
not
argument that it
known
should be a suspect class,
Okay.
separate from
But
everything.
they're saying-
You're saying this one?
What finds it is
Or
suspect.
this one? This one. Oh, okay, I was like, wait a second.
Yeah.
Right.
There's no way those.
Uh,
But even if it were rational basis, it still doesn't mean it's correct.
Right, so then they go here, and then they kind of,
Oh,
We all knew.
Belt and suspenders.
I
didn't even notice that.
That's okay.
It's really horrible.
So even if we don't get suspect class,
Right,
the law still fails rational basis review.
right.
And then scenario, why fails rational basis review.
Is that Romer?
Well, they talk about, yeah.
So this is, I mean, there's also kind of
about-
trying to get you guys to read these briefs in a functional way and dissect them, and get them to line up with the analysis.
Response performed.
So they say here, for example, because there are plausible reasons for California's adherence to the traditional definition of marriage, judicial inquiry is at an
This course
end.
precedent is clear that rational basis review.
And that's correct, right?
What page are you on?
37.
Right, that's a true rational basis review.
Yeah, it is, but they all go on to tackle the animus issue.
So here's what we need to go through rational basis.
And then there's, they're sort of talking about animus as moral disapproval. First Circuit, and also Justice O'Connor said this, a lot of people are citing to this concurrence in Lawrence right now. She's like, well, it's totally different, criminalizing homosexual sodomy is totally different than
So we wanna
saying marriage
say-
should be between a man and woman. We all know that's
When
okay.
a state
Right.
action discriminates
So-
against
Yeah,
the
that's
state
That's
class,
part of their rule.
Is this the rule?
But this is the rule from Romer, I think.
They're saying, if just because it's it is traditional, and that's not the same thing as
So
animus.
what is that?
When state action.
When state action?
Millions of Americans who believe in equal rights for gays and lesbians draw the line at marriage.
Discriminates
you know?
against discrete
The,
classes.
the idea is, unless this is sort of, unanimously hate-fueled,
It
There's
must
not
bear
any
our
discrimination.
cross.
Yeah, basically discrete discrimination. Not that a rationalization to be done.
Because then the other challenge too is to match up these two arguments and say, well, who's right? Right? What are they saying
Must
about
bear
animals
rational
versus what are
relation to
they saying here
nature.
about animals? Can you determine based on the case law who's actually correct?
I mean, that's a hard thing too, especially
rational
at
relation
the
to
Supreme
legitimate
Court level
animal.
where, like, if they take on trying to rationalize that doctrine, I mean, you also don't want to be caught between, like, if both of them are wrong and you're trying to
Right.
yourself. you know.
Right. Right. Well, that's why the court needs my article.
Is
To
that
help them out with this question. No, I mean, it's really tricky because if you don't, the parties aren't going to give you part of the picture.
Protect our
You
children.
know, and
Now just arguments.
you're not just choosing
Essentially that.
Mhm.
between them.
rational basis.
Right.
right? You're actually
Responsible
independently
for
investigating
So it's the means.
with the guidance of your judge, what the situation is.
But it's
And
under,
this is almost another thing,
How's it go there? This part's harder.
So, I mean, we're gonna need to nested outer acts here as far as, rational basis.
Because
or
they're
rational
kind of doing
relation
like a
and also
rumor.
legitimate.
Aren't they, they're doing like a Romer rational basis of fight, it seems, because they talk about.
Well, I highlighted one of the footnotes here.
Don't know what I think.
I thought this was an interesting evidentiary issue. On page 39, footnote 6,
Oh, yeah.
they're talking about the fact that proponents didn't present witnesses at trial to be cross-examined, but instead they're relying on sort of, social science reports and things like that. But who has the burden under rational basis review?
the challenger.
The plaintiff, right?
Yeah.
That they're sort of talking about there not being, they failed to present evidence of X, Y, or Z. So that's a quality one associates with rational basis of fight. Well, so the first thing you could do is to set up the proper interests, right?
But when they talk about the proper interest, but I don't know how to make that analysis.
Okay. So the application here is, so first of all, and
I'm not sure I
it
really
should
understand
all
what
be
they're saying about Romer.
99 nested IRACs. This is just a
Yeah.
shorthand, okay? So for example, appropriation, right, responsible appropriation. And that's gonna break into, is that what it is?
Because they're really just drawing distinctions.
It's probably
They're not like-
rationally related. There's the exclusion of same-sex couples rationally related.
They're just
Is it
disagreeing
legitimate
with
state
the
interest? Of
reliance.
course it is.
It's weird.
How does
It's almost like a-
excluding same-sex couples from marriage
I feel like-
advance?
I feel like-
How does it affect the behavior of
What Romer said.
heterosexuals in terms of their choice to marry, their choice to procreate, et cetera? Okay.
Yeah.
Kinda,
Okay, so let's do remedies then.
Plaintiffs here, the respondents are going to go through each of those proper interests and explain either that it's not a legitimate state
Ninth
interest
Circuit.
or it's not rationally related. And then they're gonna hit.
Or
Okay,
missed.
so then we want to
construed,
say.
missed.
So then it would just be
Something.
government interest, purported interests are.
Mm-hmm.
Okay.
Exactly.
Okay. So.
Okay, guys, just spend a couple more, a little bit more. We're not gonna finish this all the way, but I want to sit down and talk about it.
So, it was just perceived, the argument that they're perceived.
Oh, yes, that's a tough one. That's a tough one to figure out here.
So, 1, and then 2 is proceeding with
Yeah.
okay.
Yeah.
And that is
That
a
goes with the
legitimate
same.
state interest, but it's not rationally related.
Is it a
I
one?
guess it is the issue statement.
Is it?
It's a question.
I think so,
Okay,
yeah.
so,
I don't see why.
I don't have enough space to write them all out, but the reasons that
Did
they,
it say it is? No,
So,
right?
I think basically the rule could be like substance, not
Is it under rational basis, like anything?
like the Romer really said.
I mean, it's a legitimate state interest, but it's not rationally related here because we already allowed,
Step away.
California already allowed.
Well, they're saying that there is no, because they're saying proceeding with caution, which will forestall the possibility of long-term social consequences. They say that
I'd say it's not rationally related, I mean, we're in some kind of line.
Here.
Mary is likely to cause the parade of great
Okay.
horrible the reed conjures. Yeah, I think they're saying there is no administrative interest.
I don't think they're taking a
Yeah,
position on
it
it
feeds
that
into
much,
the
honestly.
protection stuff. Because they have discussing purposes really here, they're just sort of asserting that.
No factual support that permitting gay men and lesbians to marry is likely to cause, that's this.
Okay.
Okay? So they're focusing on the tailoring prong. And one of the responses I can see to this is the court saying, you know, they don't have to, the ordinance not on them to provide factual support for this. Yeah, I think this is all about the tailoring prong. This is
Am I convoluting these
part of the
two?
argument. Okay, guys, I hate to cut you short, but I want to sit down and sort of talk about the process of what we just went through and why, and I want to hear about what you're thinking in terms of your outlines.
Okay.
So first thing, just to clarify, we do not have class meetings next week, okay? No class meeting on Monday or Wednesday. We do have our hour-long individual conferences at which you're going to present your outline to me. And it's really, you know, just the further you are with your outline, the more you're going to get out of the conference, but you should have at least something. And how far you go with it, you know, it's really up to you. So I will send you guys an email to set up the times when we convene and things like that. But so, first of all, give me some reflection on this process. Can you see how this would help you in drafting an opinion, or does it feel more like, why am I doing this, kind of? And that's a fine answer, if you want to say it.
I think it's very helpful. I think it's hard to not insert like my own thoughts about what I think the rule statement should be and just put it in their words.
Yeah. So your task here is descriptive. You're describing the contentions of the parties, okay?
I think it's good just because you can compare kind of side by side what the arguments are and which
Yes.
ones are you know, logically sound.
Right.
And instead of kind of taking it on as a whole, you can break down which areas you can strike and kind of not follow.
Good.
And then which ones, you know, kind of work their way to that positive ruling.
So the thing with using IRAC to build your own arguments, but also to map and critique the arguments of others, is that it allows you to check the soundness of your logic. So is your issue correct? Is your rule correct? Application and conclusion correct, right? But then also when you're looking, you know, we talked about this, you know, both sides. Well, what have they really framed the issue properly? Is that what Claiborne really stands for? Is that rule really correct? It allows you to pinpoint if there is a flaw in a party's argument, exactly what that flaw is, instead of just a general sense of, I don't agree with this. Okay, so it really gives you very powerful tools for dissecting arguments.
So if you don't agree with their actual rule statement, you can kind of go back and kind of see if they've not.
Does the case support it? Yeah. I mean, and parties will claim that cases support things that they don't support.
Yeah.
But, you know, that reading of Claiborne in particular was very bizarre. If you've read Claiborne, that's really, transposing the terms biological difference and difference in ability is very, it's just not in keeping with equal protection jurisprudence. Any other thoughts or reflections on this process?
I think it'd be nice for writing too. You know, sometimes I get so turned around writing stuff, it would just be nice to outline down to this level.
Oh, yeah.
You know, rather than like, oh, here's point one that I'm gonna talk about, which is how I usually outline, you know.
Yeah. So, right, so it's like, I'm talking about this, right, which is kind of more like liberal arts writing. That's just a broad characterization. But you know, this is very functional, and it's permeated by legal analysis categories, okay? So, I mean, I think some of you had some frustration because you couldn't really necessarily figure out what the parties were saying, right? I mean, you read the brief, it's one thing to read the brief and get an impression of it, it is another thing to try to outline it. And you know, again, with your own writing, can you outline your own writing in this fashion? That's pretty telling, if you can or if you can't.
Yeah.
Okay, other thoughts?
I mean, it seems like if you go to this level too, you can get down to kind of a simple yes or no answer which then supports the larger premise.
Yeah.
And so you can tell if you're kind of going the right way or not.
Yeah. It's disciplined, it's, systematic, and it's based on the law and the facts. So, okay, so good work. I didn't realize that was kind of tough. What I want to check in with you guys right now is I just want to go around real quick. Do you have a sense of what the dispositive issue, in your opinion, is going to be? And do you have a sense of a case or cases that you think are really going to be critical to, either that you're going to perhaps model your opinion after, or they're going to be critical to your analysis? So let's just start.
I was thinking that I would do that sexual orientation is a suspect class.
Okay.
And I don't remember the names of the gender cases.
Well, so I'm just writing about the gender cases now for my article. They're all over the map. I mean, they're really interesting in terms of
I haven't looked
how they deal.
specifically at though. I mean, generally thinking, or I would want to. I don't know, but
So just the cases you'd want to look at would be like Reed versus Reed, Frontiero, Virginia. JEB is a jury preemptory challenge case that's really pretty interesting.
okay.
Yeah. They have different, there's a really interesting suspect classification analysis going on in this case is because there's ambivalence about whether gender discrimination is okay that there is not about race discrimination. So there's a lot of nuanced stuff in there.
Okay. Yeah, I think that one.
And Claiborne is one of the cases that has the most suspect classification analysis. So if you're really interested in that too, that might be good.
Okay.
Okay. Well,
But that wouldn't let you address animus, would it? No.
well, if you're going to end up finding animus, there's no reason to have the brain damage of doing suspect classification analysis. And that's what the Roe report did. We're not going to look at fundamental right. We're not going to look at heightened scrutiny at all. We're just going to go straight to animus. So you could, but it wouldn't be the most conservative.
Yeah, but
Right,
so
right.
then if to do animus, it would just be animus. But don't you think that if the Supreme Court now is going to talk about animus, they need to
Figure out what the heck it is?
Yeah.
Yeah. No two ways about it. What are you thinking, Mom?
Well, looking at due process, I think that opens up a little bit too many worms because it gets too broad as far as the fundamental right for all people. So I kind of want to avoid that.
Okay. That's a good way to make the decision, actually.
I'd say that equal protection, as far as a suspect class, I don't think it's going to be justified to create sexual orientation as a suspect class. So let's avoid that. Rational basis review, I'm skeptical of almost because it seems so easy, and I don't think it's the right decision.
Well, but that would be a very interesting route, okay? So, and this is the thing too, let's say you really want to get into rational basis review, and maybe if you want to conclude that proponents win, that Proposition 8 is constitutional,
Right.
you would have to reject the arguments for heightened scrutiny, but you can literally bracket that, right? So write the part of the opinion that you really want to write, if it's rational basis review, and then, we'll just insert little placeholders like, in prior portion of this decision, the court concluded that sexual orientation was not a suspect classification or whatever. So you don't have to necessarily cover every part of the analysis, because what would be very interesting about focusing on rational basis review is if you, and this is a monumentally difficult task that constitutional law scholars are not, necessarily prepared to undertake, but tell us what rational basis review is. That's a huge question,
It seems like it's something that's been used frequently for years, but it's never has like a clear factor. Well, and it does a couple, but it's like so broad that
it's not a clear standard. It's not a clear standard at all.
as far as going into like legitimate state interest and like rationally related, it's almost like the function or process is clear, but then like the factors or what they're actually considering never really gets defined.
Yeah. What is rational relationship?
Yeah.
Is it non-arbitrary? Does it actually have to move the ball forward? Does it have to move the ball forward 10 yards, 20 yards? So think about that. That might work. And if you want to focus on rational basis review, then you're talking about I mean, basically, they're the weak rational basis review cases like Heller versus Doe and SEC Communications versus Beach Communications. And then the strong rational basis review cases, Romer, but that's such a crappy case. Claiborne actually, I think, is the best strong rational basis review case.
Okay.
Okay. Karen.
So when you're talking about bracketing, so like if someone were to do sexual orientation as assessed by class, then you wouldn't talk about rational basis. Like, are we basically, if you were to do equal protection, you talk about like one of these three?
It depends.
Okay.
It kind of depends.
Okay.
Because if you were to conclude the suspect classification, or the sexual orientation was a suspect or quasi-suspect classification, the application of heightened scrutiny, probably pretty quick and dirty, right? Because it's not going to pass heightened scrutiny.
But getting there, explaining why.
That's the meat of the analysis, yeah. So depending on how involving that is, you can either bracket the application a little scrutiny altogether, or just have it be really short.
Okay.
Okay. So you're thinking maybe suspect classification analysis?
I mean, that's what I would like the court to do. I haven't
then do it.
like all the research to see how to get there, but that's kind of what I'm thinking is interesting.
Good. No, I think that's great. And so they're the cases that I mentioned. So they're the cases where a suspect class is found or designated, and then there are the important cases where the suspect classification is denied. So you'd want to look at both sides of that. Okay. Allison.
I'm definitely leaning towards focusing on rational basis review because I'd like to see it fail rational basis review.
Okay.
So I'm struggling with the legitimacy of the governmental interest. So
Yeah, okay.
that's something I'd like to really focus on.
Okay.
I like the findings of fact from the district court. So
Yeah, you can use that. And the respondents brought those up quite a bit in their brief, so.
I hate to go back, but I mean, like, can we kind of come up with our own definition of legitimate state interest or rational basis?
Well, I'd like for you to use some cases, do it.
Well, yeah, I mean,
But-
of course, but I mean, if we
Well,
can
so
kind of,
if you want to articulate a better rational basis review standard, that would be awesome.
yeah,
And you ground it in precedent, that would be great.
we could go that far if we wanted to.
Oh, yeah. That's what's good
That's
to
what
judge.
we should do, right?
Well, especially you're writing for the Supreme Court, so yes, it's your job to articulate new rules when
Yeah, especially
required.
like when it's, I mean, every state Supreme Court is going to apply the same kind of rational basis review, wouldn't it? On their own laws, or would,
I don't know, not necessarily, I mean, it depends, yeah.
okay, it's kind of going off basis there.
Yeah.
All right, Bill, Bill Clark. You're up.
Yeah, I'm really not sure. I almost feel like we should pick 5 paths and draw straws or something.
To be fair, do you want me to assign you?
Okay.
Really?
That's how I feel too, so I just picked one.
Let's have Bill argue that Javi wins under strict scrutiny.
That would be cool. What do you do if I'm not right?
Okay.
And you guys are obviously all free to change, but just start on a path, figure it out. Zablocki, so the cases recognizing marriage if I'm all right, Zablocki, and Loving. Skinner kind of gets into it from the procreation angle more. But Bowers talks about it, and Lawrence doesn't really refute it. But so you want to look at some of those cases.
Someone's got to go for your animus topic.
You don't write a paper on something that your professors.
Just like Steve Pollvogt. Just like cite her. That's wow, yeah.
Yeah, but if I want to be a justice that cites secondary sources.
Yeah, no, I think the animus is really interesting, but I just didn't know how to do that without like just citing their law review.
Oh yeah, no, that's. There's a lot of different things to be said about animus.
Oh, that's awesome word.
What I want is I want the Supreme Court to cite the article, but
Should have done that.
we'll see.
Yeah.
I was going to.
It's kind of a real possibility.
Have you sent it to them?
I haven't yet, but I influenced you this week. And then, you know, the amicus brief that we filed, we all cited our own work in there, obviously, so it was good. Okay, guys, that sounds good. So hack away at your outline.